FSB. FSB.
Good morning, everybody, and welcome to the FSB webinar. We're Sexual Harassment in the Workplace. My name is Lindsay Luke, and I'll be your host today. So from the 26th of October 2024, there is a legal duty on employers in England, Scotland and Wales, requiring them to actively take steps to prevent sexual harassment in the workplace. This webinar is aimed at helping you ensure your business is up to speed with insight and guidance from experts at FSB Legal and the Equality and Human Rights Commission, plus practical advice from an employer. Today, I'm joined by solicitor Hannah Thomas from FSB Employment Advice Line, which is delivered by Markel, Sam Bonza, Director of HR at the Federation of Small Businesses, and Rebecca Thomas from the Equality and Human Rights Commission. So, welcome everybody. And let's get started with our first question. So what is the new legislation and how did it come about? Rebecca, is that something you can cover for us?
Hi there. Good morning, everyone. Yes, so a little bit of background. The Equality and Human Rights Commission is responsible for enforcing equality law in Britain. And we're also responsible for providing advice and guidance on the extent to which people's rights and sort of employer obligations are captured in the legislation. So in terms of this particular legal change, what we saw way back in around about 2017 in the light of the Me Too movement was sort of increasing disclosures and awareness of the extent and the impact of sexual harassment in the workplace. And the EHRC did a call for evidence to understand exactly what was happening, what employer responses were like, and what employee and workers' experiences were. I think it's worth sort of flagging from the start that obviously under Equality Act 2010, sexual harassment is unlawful. But despite those existing protections being in place, it remains sort of poorly, poorly enforced, underreported, and it continues to be widespread. So in 2017, we did a call for evidence, and that led to our report Turning the Tables. And what that did was sort of outline the scale of the problem, as well as sort of try and develop practical solutions and improvements. And we heard a range of evidence from individuals and employers. And that really sort of got to the heart of the issue, which was essentially that a lot of people didn't bother reporting their experience of harassment because of concerns that their employer wouldn't take it seriously, or that they would be victimised if they did so, or even simply that the employer didn't have an appropriate reporting procedure. So the other thing we found is that actually there was a lack of sort of consistent responses from employers to when there were disclosures of sexual harassment in the workplace. So it was quite clear that employers were also struggling to respond effectively to sexual harassment in the workplace. So off the back of all of this evidence, what we sort of considered might be an appropriate way to resolve this was to sort of require employers to take reasonable steps to prevent harassment of their workers in the workplace and to make that a mandatory requirement. And we also wanted to see the reinstatement of legal protection from third-party harassment. So the preventative duty essentially would shift responsibility onto the employers to take positive and proactive, reasonable steps to prevent sexual harassment of their workers. And it's a sort of an important cultural shift from redress to prevention, sends a clear message to all workers that they are protected from unlawful harassment. So these recommendations was also mirrored by a number of other bodies, including the Women and Equalities Committee, which did an inquiry back in 2018 and sort of reiterated a recommendation for there to be a preventative duty. Now, off the back of that, the government decided to consult on whether they should introduce such a mandatory duty, and that took place in 2019. But then it all went very quiet, nothing happened. And it wasn't until 2022 that Vera Hobhouse, who's a Liberal Democrat MP, introduced what's known as the Worker Protection Act. And she introduced that as a private member's bill, but it had government support. And what that did was introduce a mandatory duty on employers to take preventative steps to protect their workers from sexual harassment. And And really, that's where we are now. So that new duty came into force, as you said, on the 26th of October. And there is now this obligation that employers sort of front load steps that they can take to prevent their workforce from sexual harassment.
Brilliant. Thanks for that summary, Rebecca. So Hannah, what does that mean then for businesses?
Yeah, I mean, what this means for businesses is, as Rebecca has already summarised, is that employers are under a new proactive preventative duty to prevent sexual harassment from occurring in the workplace in the first place. And as Rebecca has summarised, sexual harassment was already unlawful under the Equality Act 2010, but the law wasn't sufficient in helping employers address that issue, and it was an ongoing and serious issue that was identified in the workplace. So what this means in practical terms is that if an employer, or rather in legal and risk terms, should I say, that if an employer doesn't put in place those reasonable preventative steps, then employees can individually enforce that breach. And they can bring a claim in the employment tribunal. And if that claim by an employee or an ex-employee is successful, then the employment tribunals now has the power, now has the right to apply an uplift to the compensation for sexual harassment that is already payable. And that uplift can be as much as 25%. So it is a very significant financial risk. And also the Equality and Human Rights Commission can take preventative action. So whether or not an employee or ex-employee brings a claim, they can still take preventative action just to ensure that employers are complying with that preventative duty where it's necessary. As sexual harassment has already been unlawful, it continues to be so, then this is very much about being proactive in terms of addressing your workplace culture. The reasonable steps, it's really going to vary from employer to employer in terms of what is reasonable. So there are factors like the level of risk, that how great is the risk that sexual harassment is going to take place in the workplace, the type of risk, what kind of sector the employer is in, the resources the employer has. So generally speaking, as a rule of thumb, small businesses may not be expected to put in place the type or number or level of measures as larger employers. So obviously our audiences are small businesses, so and also our guidance is very much geared towards small businesses on the own FSB hub. This is an interesting point, because there is a bit of confusion around this, and it's very understandable why there is this confusion, that employers are still expected to take steps to protect their employees against sexual harassment by third parties. So as well as employees, as well as sexual harassment by colleagues, employers are expected to take reasonable steps to protect sexual harassment from occurring by third parties, such as clients or customers. However, individuals can only bring claims where their sexual harassment is carried out by other employees, and they can't bring a claim in the employment tribunal where the sexual harassment is committed by third parties. Now, given that, as with discrimination claims, as with all discrimination claims, compensation for claims for sexual harassment claims are uncapped in the employment tribunal. So this does create a bigger financial risk for employers if they haven't done enough, and if the employee or ex-employee brings a claim in the employment tribunal. So that's obviously the big risk, as it were, as well as obviously cultural considerations and moral considerations, reputational considerations for employers.
And is there anything that hasn't changed?
Yeah, so what hasn't changed is, of course, the Equality Act. Under the Equality Act 2010, sexual harassment is and continues to be unlawful. But what has changed is this shift in expectations for employers in addressing their workplace culture. So it's not really about putting the onus on individuals to bring a claim and to enforce that claim. Now the onus is on the employer to really think about their workplace and think about what sort of reasonable steps they can put in place. And it's also, there's been a shift to thinking about risks. This is quite a new concept for employment legislation. We're quite familiar with it for health and safety legislation, for carrying out a risk assessment for physical and mental health risks. But this is a kind of a new change of emphasis in terms of how the employer is expected to approach employment legislation. So it's an interesting one, actually, for employment lawyers as well.
Brilliant. And it's probably worth at this stage giving a legal definition of sexual harassment. Can you do that, Hannah, in your legal
Yeah, no,
question?
absolutely. I mean, sexual harassment is set out, so it's defined in the Equality Act. So it's defined as unwanted conduct of a sexual nature. And that's conduct which either violates the employee's dignity or it creates an intimidating, hostile, degrading, humiliating or offensive environment for them. And now, given this definition covers a wide range of behaviours, and where the behaviour is unwanted, so it's going to include things like unwanted sexual advances, requests for sexual favours, but also less obvious behaviours. So it's behaviours which could be verbal or non-verbal, as well as physical conduct of a sexual nature. And it relates to employment-related conduct. So employment-related, it's quite a wide remit. So it's not just the harassment that takes place in the physical workplace, but it's also covers work events or perhaps online contact, such as communication on WhatsApp, where WhatsApp is used for work, or perhaps social media in a work context. I think the really interesting point to stress about this is that the employee doesn't need to be the intended target of the harassment. And this is important because some people may find certain behaviours or perhaps workplace banter of a sexual nature acceptable at work, but that doesn't mean that others do. So it's very much about looking at your workplace culture and putting in place reasonable measures. I'm thinking in particular of a recent or perhaps more extreme illustration of this, and this was an employment tribunal case this summer, and the owner of the business described various aspects of his sex life in quite graphic detail in the office. Other staff didn't complain about this, but the employment tribunal did agree that this and other behaviours in the workplace amounted to sexual harassment when a new and relatively junior recruit brought a claim, amongst other things that included a claim for sexual harassment. So it's really about having kind of more of a holistic look at your workplace and the kind of behaviours and looking at the workplace culture.
Brilliant, thanks for that, Hannah. So let's get into the practical detail of how this works. So FSB is an employer itself. We've got just under 200 employees. So Sam, how have you approached the new obligations?
Yeah, so the way I thought it was best to approach it is to look at those three areas. So you've got the financial risk, you've got the reputational risk, and you've got the cultural risk. And I always think if you're thinking about your culture, you can use the legislation as a tool to create a cultural shift or to just reinforce areas of your corporate culture that are already there and that are already really good. So we are very fortunate in that we have the Markel Legal Hub. So if you're a member of FSB, if anybody watching the webinar is a member of FSB, you can go onto the Markel Legal Hub. And I did this myself. So I have a HR team, but I utilise the resources that we have at our disposal through Markel. And they have a great range of tools that can help you in terms of fact sheets. They have a template sexual harassment policy. They have a risk assessment, and I utilised all of those. So I started, as I would do with any kind of piece of legislation, do our policies that we have in place at the moment accurately and fully cover the legislation? So I looked at what we have at the moment in terms of our equal opportunities, our anti-bullying and harassment policy, and it wasn't quite specific enough. So I did utilise the template policy that we have on our FSB Markel Hub, adapted it slightly so that it suited our organisation, because every organisation is going to be different. The law is the same, but the way that your culture is and the way you interact and the different circumstances that your employees are under is going to be different for everybody. So I looked at that and I then thought, are there any other policies that kind of link to that might need changing as well? So as Hannah said, this isn't just about things that are face-to-face. So lots of people utilise social media these days, staff to staff as well. And there's all different kinds of social media. So I looked at our social media guidelines for our employees to make sure they were clear enough. And again, they just needed tweaking. They needed to be a little bit more specific. I was then thinking about, okay, so I have in place the practical things that I've needed to change in terms of our policies, but who do I need to communicate that with and how do I do that? And a great place to start with this and it's one of the requirements anyways to do a risk assessment. So again, without wishing to plug too much, the Markel Legal Hub has a great risk assessment tool. Again, you need to adapt it for your organisation, but in terms of a starting point, it was really good. And it actually made me think about things that I hadn't thought about. And it covers everything. So you're thinking about the entire employment relationship. So it's not just when you're in an office. For us, it's when we're at events, when we're with our members. And although, as has already been said, we don't have third-party liability at the moment, it's likely that that is going to come in the Employment Rights Bill. So you can almost give yourself a head start by having that in the back of your head. And if you can do things now, little tweaks to things now that will help with that, there's no harm in doing it. So I looked at the risk assessment, did a risk assessment for different groups of employees, different circumstances that they come into, discussed it with senior managers who it was relevant to. So what are these groups of people where there is a risk? How do we communicate with those groups of people, and what are those specific risks? So I looked at the way to communicate, and I always think not everybody takes in information in the same way. And this isn't just about ticking a box. I created an action plan, which again is part of our taking reasonable steps. So I did an action plan of the different groups of people based on my risk assessment, looking at my template policy that I now have, and looked at how do I communicate with people and in what way. So again, if you're, depending on what your business is, I am very fortunate in that all of my staff have access to Teams. That's how we communicate. We have an intranet. But I used to work for businesses where people were drivers and didn't have email addresses and didn't have intranet. So you have to think about your teams and how's best to communicate them. And the way I chose to do it was I did a really brief 5-minute video clip in the run up to the legislation changing, saying, this is a new thing that's coming in. We're going to be doing some communication around it. We want you to be aware of it. So keep an eye out, because I'm going to be putting things on our intranet. I'm going to be doing some training sessions. So you're kind of giving people a preemptive, and it was a little video clip, small bite size. Then I did a blog on our intranet. Our intranet is very well used. Some of them are, some of them aren't. So again, you need to think, is that the right tool for you? We have an all staff Teams channel, so I put the video on that. And then I looked at doing departmental meetings, and they were all slightly different depending on what that group of people was. So if it's a group of people who do lots of evening events where there's alcohol, does the risk increase? Yes, it does. Do I need to make them aware of that increase in risk? Yes, I do. And the overall message for all of them on the managers training sessions, on the departmental meetings, to make it part of our culture was, this is all of us. This is not about a business owner or a member of HR enforcing a policy on you. This is about a piece of legislation that enables us to have the right culture that we should have in this day and age, and that it's an expectation of all staff. So we explain to all staff what sexual harassment is, what the behaviours can look like, and that our expectation as a business is that we behave appropriately to everybody, and that everybody should be empowered to stand up and say that's not appropriate if it's not, and make sure they know where to go, how to communicate it, what could happen with that communication, how it will be dealt with. But overall, to really reinforce to people, please do talk about it, please do come to us. To managers, be the eyes and ears, be the ambassadors of good behaviour, and to be proactive with it. You know, if you have people in your team who you already think could be crossing the line, it's about being proactive and reinforcing the right culture. And then it's remembering this isn't just a one-off. So we can do all of this stuff right now, but this is an ongoing obligation, and your risk can change over time as well. So if the things that your staff are doing change, if there's new activities that come in, it's remembering to go back to that.
That's really comprehensive, Sam, and it sounds like the legal helpline, Legal Hub and the helpline has been really useful for you. So you mentioned there that you need to change it over time. So how often will you be revisiting your policies that you've just created and that communication plan?
So I think it's good practice anyway, on a kind of annual basis, to review what your employment policies are. I think that is good practice. But I will be looking at it. I do internal manager training courses. Every time I run that course, I will look at it again and reassess it and think, has anything changed? I will do it on induction training for staff as well. So every time I do that, I will have a look at it. I will see, has anything changed? And it's also, things may happen. So if people do come to you, if you do have cases that are brought forward, that could change you. That could mean the risk increases a bit. If it increases, is my action plan still sufficient? Do I need to do something different? So at a minimum, it will be annually, but it will be on top of that when I do training, when there may have been an incident, when some activities change, and when managers bring things to my attention. So anything that changes in the environment, any new people come in, any new circumstances, plus a general annual refresher.
Great, thanks for that, Sam. So Rebecca, what support does the EHRC have for businesses out there? So we've heard about the Legal Hub, which sounds amazing. So what other support is out there for people?
So the EHRC obviously has a really important role in making sure that the legislation is properly understood. To support that, what we've done is redo our technical guidance on workplace harassment, sexual harassment. And that's very detailed and it's very complex because obviously it's the kind of definitive interpretation of the legislation. But to sort of recognising as well that, you know, as Hannah and Sam have both indicated, that actually there are going to be a range of responses required from different sized employers, depending on their circumstances. We've also produced a kind of a quick start guide, an 8 steps guide, which sets out the kind of the key principles that we would encourage employers to look at and consider how those can be applied in their workplace. And it's interesting, as Sam was talking, I was going kind of ticking off, because it's basically she's outlined all of the principles that we espouse in this 8-step guidance. And that includes things like revisiting your anti-harassment and bullying policies, making sure that you're communicating with staff, offering training, reviewing and monitoring that, making sure that you've got an effective sort of reporting mechanism in place where, sort of recognizing sort of the need for anonymity or, confidentiality. Really good, sort of emphasis on taking a risk-based approach to understanding how sexual harassment might happen in the workplace. And then obviously, of course, what to do when a harassment complaint is made, because, despite this being a preventative duty and the intention is to hopefully shift the culture so that there will be a big reduction in instances of inappropriate or sexual harassment. We're dealing with people, aren't we? And there is always the risk potentially of this happening regardless of the steps that employer can take. So it's absolutely imperative that, as particularly Sam, as you were saying, that you kind of pause and reflect when disclosures are made and understand, well, what does that mean and how can I do, how can I improve the protections that I've got in place to make sure that staff in future are protected. In addition to those sort of kind of more general resources, we also have some dedicated sector-specific content. So, for example, we did a toolkit with the UK hospitality sector back in, I think it was 2023, which looks predominantly because we know that the sort of prevalence of sexual harassment in the hospitality industry is really quite high, and it's a combination of risk factors, including, a young workforce, lots of people on insecure contracts, and presence of alcohol as well, which is another big one. And that sets out very similar kinds of principles. So while it is sector specific, there is going to be a lot in there that's going to be relevant to all employers. And I think it's worth sort of re-emphasizing the point too, that every employer is in scope. So every employer will need to do something, but what employers do in response to the risk factors they've identified is going to vary widely depending on the resources, the scale of the organisation and the types of risks that have been identified. So hopefully the combined resources that EHRC has produced, the ones that the FSB has available to its members, are going to provide a really good sort of basis for FSB members to consider and then start taking action to protect their workers from sexual harassment.
Thanks, Rebecca. And Hannah, I know Sam and Rebecca have both mentioned the FSB Legal Hub and the helpline. You're in it, you're working in it day to day. So can you bring that to life for us? And is there anything else you want to add about what support is out there for our members?
Yeah, I think Sam has given such a great illustration of how the resources that FSB have been used in a really kind of practical way. Can't really add anything more to how Sam has really eloquently kind of illustrated that point, which I think is going to be really useful for businesses that are listening. But it's just really just to remind anyone who is an FSB member who is listening today to really utilize those resources that you've got. And those resources are access to a legal advice helpline staffed by employment solicitors, my colleagues, and also access to the FSB Legal and Business Hub. And as previously mentioned, you can find their fact sheet guidance and also a template sexual risk assessment and a sexual harassment policy. So yeah, I really do strongly encourage members to utilise those resources that are available to them. And and if in doubt, just pick up the phone, book a call, and speak to my colleagues on the advice line.
Thanks, Hannah. So Rebecca, how will this new legislation be enforced? What does the EHRC, will they be doing to look out for these issues?
So obviously, as Hannah outlined at the beginning, if an individual takes a complaint to the employment tribunal that they've been sexually harassed, the employment tribunal will also consider whether there's been a breach of the preventative duty. And if so, they will issue a compensatory uplift of up to 25%. So obviously, that's one way in which the measure will be enforced. In terms of the EHRC's remit, there doesn't have to be a sort of a breach of the in terms of an individual claim of sexual harassment. So if individuals are concerned that their employer is not taking preventative steps to comply with the duty, they can report that to the EHRC using our whistleblowing mechanism. And what we are doing, obviously, is sort of taking an evidence-based approach. So we're very similar in terms of our size to FSB, and we have to enforce the entirety of the Equality Act. So we need to take a very targeted and strategic approach to enforcement, and mainly that's to ensure that we are addressing sort of particularly grievous breaches where it's particularly severe, or where it might be substantial in scale, where we see kind of potentially repeat failures or challenges around compliance, and we'll take this evidence-based approach to determine where we use our enforcement powers most effectively. So the first off, though, is the priority for us is to make sure that employers understand what their obligations are, and that's why we've issued guidance and other resources. So the kind of compliance piece is our priority in the first instance. And what we're going to be doing is over the coming months is sort of monitoring and seeing what happens, what sort of reports we get back through our whistleblowing mechanism. We have a triage team who sort of monitors disclosures and sort of intelligence from other stakeholders. Might also be, information insights from FSB, other business sector organisations in terms of what's happening, where employers might be struggling, to inform them whether there's sort of additional compliance activity, further advice, guidance, or whatever that we could issue. But where we become aware of sort of, particular breaches, we will sort of triage to determine, as I said, what the kind of the scale of the severity and the impact is of that, whether it's appropriate for the EHRC to be taking enforcement action, whether there are other ways in which we could address that through compliance activity, for example, or sort of consider whether we do actually need to deploy one of our sort of more sort of robust legal powers. And there are a range of things we can do, which includes things like entering into a legal agreement with an employer, which will require them to design and implement an action plan. And FSB members might be aware that EHRC has done a lot of work in this space on sexual harassment with organisations ranging from McDonald's to Sainsbury's or IKEA, where there have been continuing challenges around workplace sexual harassment. But I think the important thing to remember is that we do take a sort of a facts-based approach, and we will look very carefully at the circumstances of each disclosure to consider whether actually the employer is meeting its obligations or not, or whether actually they need further assistance before sort of moving into a kind of a formal sort of legal action.
Thank you, Rebecca. Now, I should have said at the start, so we've got the Q&A open for anyone who wants to put a question into the live session, but we have had some questions in advance. So I'm going to turn to you first, Hannah. So we've had a question in from John, and he says, given the higher level of accountability on employers, should they cancel the Christmas party?
Okay, well, we're coming up to Christmas, aren't we? We're coming up to the festive feast season, and I don't want to be a party pooper, absolutely not. So yeah, in short, I would say absolutely don't do that. Don't cancel festive activities for your staff, because it really is about putting in place reasonable measures. So it's not, the aim is not to completely eliminate risks. That's not what the intent of the legislation is, or the guidance, but it's about putting a proportionate response. So in the context of Christmas parties, as an example, or any workplace events, you know, summer parties, sort of general workplace events, reasonable steps. It's really up to the employer. Obviously, you know, in terms of your communication to staff, what's going to be appropriate, you know, the appropriate tone to strike. But an example might include reminding employees by email, as well as obviously the practical arrangements for the event, the expected standards of conduct. So obviously, we still need to be respectful to one another. That does include, of course, avoiding unlawful activity, and just remind them of the key aspects of any relevant policy. You might, if you're an employer, want to limit the availability of free alcohol, not just in terms of the risk of sexual harassment, but that's just generally a good idea in terms of risk generally. And you might want to ensure that employees can get home safely after the event, so they've got access to transport. And of course, if you do receive complaints of harassment, then you're going to, as an employer, have to deal with that complaint appropriately.
That brings us on to the next question, actually, Hannah. Thanks for that. So Youssef has asked, how should you manage complaints and how should they be dealt with?
Yeah, I think the starting point is you want to treat them seriously, and you want to reassure the employee as far as you can that you're going to maintain confidentiality. And it's not about insisting that the employee has that complaint dealt with in a certain way. So, for example, they might want it resolved informally, but if it's a very serious complaint of sexual harassment, that's not going to be appropriate, and you're going to want to ask the employee to follow that formal grievance process. It's about understanding what the employee might be hoping for as an outcome. That's not necessarily going to dictate the outcome for the employer, because they're going to have to manage it in accordance with the law, and they're going to have to manage it in a proportionate and a fair way. I think what I would say to the employer is be careful in terms of how you manage that complaint or grievance, obviously not to inadvertently cause victimization for the harasser themselves, or, for example, insisting that the harasser kind of move role or move area of the workplace to avoid coming into contact with the harasser. More appropriate would be to consider whether you would want to or need to suspend the harasser from the workplace. And of course, the key with any complaint, not just a complaint of sexual harassment, is going to be in carrying out a reasonable investigation. So yeah, these are the key points I would say that the employer should bear in mind if they do receive a complaint. And it's really important that managers have received the appropriate training so then they know what to do when they do receive a complaint.
And another question linked to that. So if somebody does make a complaint, I think this question came from Jenny, and then they say actually they don't want to follow it up with the alleged perpetrator, does that mean you can't take any action? What position does that put the employer in?
Yeah, this is not uncommon, actually, and we do find on the employment advice line that an employer will contact us in that situation. So, for example, an employee has raised a complaint, typically with their line manager, and said, look, I don't want this to go any further. I'm just letting you know that this is happening. And there could be a number of reasons why they don't want it to go further. And we've obviously very aware of the underreporting of sexual harassment, and those reasons could be because the employee fears retaliation, or they don't want to be seen as a troublemaker, or they don't want to rock the boat. So there can be many reasons, and for the employer it's important to deal with this in a compassionate way, but also be proactive about it. So you need to explain to them that if they don't provide you with the relevant information, then it's going to be very difficult to carry out a reasonable investigation, because you're going to draw a bit of a blank in terms of what the appropriate next steps are. But the employer does have a duty there to still investigate. And another situation that does sometimes happen in terms of queries we get on the advice line, they would say, well, look, there were no other witnesses. So it's a question of he said, she said, so no, how can we meaningfully investigate? So we will say to the complainant, look, we're not going to investigate because we can't reach a conclusion. But there still is a duty on the employer to carry out an investigation based on the information that they have. And even if that's very minimal information, they still need to come to some conclusion whether there is a case to answer, whether to uphold the grievance or not. Because, you know, at the end of the day, if you decide not to investigate complaint because of lack of evidence, then you wouldn't have met your new proactive duty to take reasonable steps to prevent it happening. And also you're on notice that there could be an issue as well as an employer in that situation.
And a question that's coming from Juliet: is there an obligation for the employer to report sexual harassment to the police if it's a serious case?
If it's a criminal case, then that really is for the employee to decide, because obviously they are the potential victim. So it's for them to decide whether to report that matter to the police. Now, if there is a very obvious risk of harm, then the employer would want to consider reporting that to the police, but they really want to get the employee on board and understand what the employee wants to do and give them the appropriate support. So I would say it's not automatic that, you know, the employee, it's not their duty or place to consider whether, you know, to report it as a criminal matter. That's really for the victim.
Right, and there's been a question in from Tracy, which is probably aimed at Rebecca. Can you bring a claim against a third party? So if the employee feels they've been sexually harassed by a client. Can I hand that on to you?
So in terms of the employer response, I think there are a number of steps that the employer can take as part of the preventative duty to ensure that the, you know, risk factors as a result of the, you know, the potential interaction with third parties, whether it's clients or customers, are considered and addressed. And if that doesn't happen, then to sort of reflect and review the kind of policies and procedures it has in place to make sure that the potential of that risk is mitigated in future. In terms of sort of an individual standalone claim, if an individual wanted to take a claim to the tribunal on the basis that they've been sexually harassed by a third party, then they're currently not able to. So that provision is, there's no protection against harassment by third parties under the Equality Act at the moment. There was back in, but that got repealed back in 2013. Although I think, Sam, you mentioned that there is potential that will come up again through the government's Employment Rights Bill, which is currently progressing through Parliament. So at this point, as we said, there's no individual sort of standalone right to take a claim to the tribunal on the basis that you've been sexually harassed by a third party. But the way in which the preventative duty is worded, it describes conduct that occurs in the course of your employment. So if an individual is working and they are harassed, it doesn't specify that it's worker on worker. So if they are harassed by a worker, a fellow employee, or if they are harassed by a third party, then that's in scope of the preventative duty. So there is that proactive obligation on employers to consider those risk factors, as I've said.
Brilliant, thank you. Sam, someone's asked, where can they find the templates?
So if you are a member of FSB, we do have, if you go onto the FSB website and you sign in as a member, there is the Markel Legal Hub. And if you go into the Markel Legal Hub, that's where all of the templates are. I think the EHRC also have some templates, but certainly the ones that Markel have produced for FSB members, from my personal point of view, were great and really useful and very adaptable for your business.
Thank you. And I think this might be yours, Hannah. How is intent regarded by the new law? So if an employee does not intend to cause offence, but offence is taken?
Yeah, it's just, there's been no change under the Equality Act of 2010 in that regard. So basically, if the intention was to sexually harass an individual, then of course that's going to be unlawful. There's no question about it. Most often, or very often rather, it's not necessarily the intent to cause harassment or to create that offensive or humiliating environment for the individual. There have been lots of examples in court decisions, in tribunal decisions, where someone has engaged in certain behaviours in the workplace, hasn't been targeted at anyone. Perhaps they're watching pornography in the workplace is a very obvious example of that. And actually, employees have brought claims in that circumstance, and the employment tribunal has upheld it on the basis that very obviously creates an offensive environment for the complainant. So yeah, there is a certain objective test, an element to that. But yeah, generally speaking, it's not about it's about the environment. It's about the effect of that behaviour has on the individual.
Okay, and there's another question, so it might be Sam and Hannah maybe could answer this together, around home working and then visiting lone workers, and then someone Tracy had added, how do we protect an employee having a meeting with a client one-to-one? Sam, have you got any policies in that you have within FSB?
So I guess the first thing is that would come under your risk assessment. So that would be one of your groups of employees that has a particular risk around if they're home workers. So I guess it depends on the scenario. Is that suggesting they're meeting clients at their home, or are they going externally and meeting clients externally? It depends on the scenario, but your risk assessment will lead you to the answer of what you do with that. So you'd look at what that particular risk is. If you use a scenario of them going externally to meet people, then it's a case of, does it need to be confidential? Should it be done in a more open environment? There are lots of things that when you do your risk assessment, it should lead you to what can you do to mitigate the risk. It's very scenario specific. So I think that's how you'd start. You'd start with your risk assessment.
Anything to add on that one? Hannah? Oh, sorry, it says I'm unmuted, but I wasn't. Hannah, is there anything to add on that?
I didn't want to jump in on that one. And I think Sam gave a really practical example, because it is very specific to the employer and the working arrangement. And also, how does the lone worker normally communicate in that situation? What other security measures do you have in place for that particular individual, in terms of most people carry around a mobile phone now. Obviously, if they're in immediate danger, can they get themselves to somewhere private where they can make a call or a text? How can they reduce the risks for themselves in any given situation? And it's about supporting them, because being a lone worker is a very obvious risk factor when it comes to sexual harassment. So it's about putting in place those appropriate measures for the lone worker.
Right, and Tracy has added about private offices, so a small office within a larger office, one-to-one meetings. Any advice there? Is that just your risk assessment again, Sam?
Yeah, I mean, your risk assessment is your starting block, really. And again, it's like Hannah said, you're looking at, has this already been covered? Do you have things that are already in place? What are your methods right now? Because I'm guessing that's already been the case, that there has already been an office within an office. So risk assess it, look at if there's any instances, has that risk increased? Do you need to do anything differently? I think the answer for any of these specifics, it's difficult for us to give you an exact answer, because it will depend on the exact circumstances. But the starting block is assessing the risk on every case, and then looking at your policies, looking at your communication, looking at your codes of conduct. Does everything align in the right way?
Yeah, and another question we've had in is, does sending rude jokes by text, WhatsApp, I assume, or on social media be considered harassment? Anna?
Yeah, I give her the good old lawyer's answer to that, which it depends. So yeah, it really does depend. And it's not about creating a workplace environment where people are scared, to be relaxed, to joke with their colleagues, because that is what makes us human. But it's just being aware that there is certain very sexualized banter that it may not be unwanted for some, and they may engage in it, and it may be perfectly fine, but that is a bit of a red flag. And if the employer is aware of it, then obviously it's about kind of reiterating your policies around being respectful, being professional. I mean, I can think of many case law or employment tribunal examples of that one. For example, there was a case where these were waitresses. We're talking about obviously a high-risk sector. We're talking about the hospitality sector, and these were waitresses, and the owner of the company kind of engaged in very sexualized banter with them, and they gave it back a little bit to some degree, but that can be a defensive mechanism in some cases. We know where there's a kind of a power imbalance. You've obviously got the owner of the business, and these were migrant workers as well, so that was an extra kind of additional power imbalance, and they kind of sort of went along with it to some extent, gave a little bit of banter back, but ultimately it did result in a claim which included a claim for sexual harassment, which was upheld by the employment tribunal. And just remember now, as an employer, you've got that extra potential 25% uplift if they do find in the claimant's favour in the event of a sexual harassment claim. So it's be proactive about that sort of banter, but it depends, and it can cross a line sometimes.
If I could just come in on that as well, because I think it's something that banter's a really tricky one, jokes are a really tricky one. The way that I communicate to my staff is, you've got to bear in mind that I can be offended by something that wasn't directed at me. But I've heard it, or I've witnessed it, I've seen it, I've read it. I can still be offended by it. So just if it wasn't intended for me, and lots of us work in open plan environments now. I work in an open plan office. I can hear a conversation that's going on across the room. It's not directed at me, can still create, in my view, a degrading workspace. So you could work with the same people, and lots of us, I have staff here who have worked together for years. They know each other really well. They feel comfortable with those people, and they feel they have an understanding and they know what their line is. And what I always say to people is, but you don't know what the person who's walking through the corridor who hears it thinks. You don't know what the person at the other side of the room, how they may feel about it. And, heaven forbid somebody hears something on the other end of a phone. So just because you feel you're in a safe, comfortable space, that banter's okay between you, it's a bit like social media. It's never just between you. There's always the opportunity that someone will hear something and be offended by it, even if it's not directed at them. They're not part of the conversation. It's, do they then feel comfortable in that environment or not? And the answer could be no.
Brilliant. Thanks for that, Sam. And we've had another question, Hannah. Having this new policy, is it a zero tolerance? So if somebody has been reported and they've done something wrong, does it mean that you have to dismiss them?
Yeah, I think the EHRC take on this, or rather would be, yes, have a zero tolerance policy. But what do we mean by zero tolerance? I think that's the crux of it, because zero tolerance doesn't mean dismiss someone every time that some behaviour could amount to sexual harassment. It really is to do with the gravity, and it has to be a proportionate response. And as an employer, you're going to want to act fairly, and you're going to want to avoid the risk of an unfair dismissal claim, for example. And as with any dismissal, it has to be a reasonable response to the gravity of the misconduct. And the same with sexual harassment. It's no different. The law has not changed in that respect. So it really is about carrying out a reasonable investigation and a reasonable response. That might be a word in someone's ear in confidence. It might be a formal first written warning. Or, obviously, if it's a repeated pattern of behaviour, or if it's very serious, then it might amount to gross misconduct, and dismissal might be a reasonable response to that. So I think just be aware, when we talk about zero tolerance, we don't mean that one size fits all in terms of the appropriate response to what that is.
And just to come in on that as well, is that obviously zero tolerance really speaks to the fact that you do not tolerate the sexual harassment of your staff. How you then deal with that, and how you then deal with specific instances or behaviour, whether that's from a third party, whether that's from a member of your workforce. The issue fundamentally is that you have a zero tolerance approach to ensuring that your workers are protected from sexual harassment, and that's essentially what we mean when we talk about zero tolerance.
Thanks, Rebecca. We've had another question in around a private WhatsApp group. So the business owner is excluded, the staff are in there. Can somebody bring a tribunal if the group chat becomes offensive and they have no control of that as an employer? Anna?
Yeah, that's a really tricky one. We've seen a lot of case law. We've seen some case law involving WhatsApp work groups, but that's not in the context of sexual harassment so far. That's more in terms of the extent of the employer's duty in relation to other conduct. It really comes down to just kind of reminding employees, what acceptable behaviour is and enforcing your existing policies around social media. Remember, WhatsApp, it's a very immediate form of communication. People just generally feel more relaxed when they're using social media or WhatsApp messaging compared to email communication. It's just human nature. But at the end of the day, what you communicate can still obviously have a harassing effect for the individual. So it's just really about reminding employees about your policies around communication generally.
Yes. And the final question, Sam. So Hannah and Rebecca have outlined that the Worker Protection Act covers employees only, but it will likely to be extended in the future. So can you give an outline of what how you're approaching this from an FSB perspective?
Yeah, so I think there's two likely changes. So one is that at the moment we have to take reasonable steps. That could change to all reasonable steps, which raises the bar a little bit. And then the next point is third parties. So being having the duty to be preventative with your third parties. So what I'm looking at, and you can start doing it now, and sometimes it's worth getting ahead on some things, or at least having a plan, maybe creating an action plan for the future of what it would look like. So depending on your organisation, I, for example, have some, not our employees, they may be contractors who come in to do a project on something or work on something. And in our contract for services that we have with those people, if you think of it from a health and safety point of view, we already put in there that they have to comply with our health and safety policy because they're working on our premises. We have a duty of care to them. So they have to, in order to fulfill that, they have to comply with our health and safety policy. It's looking at, do we include in that the sexual harassment policy and our current anti-bullying harassment policy? So it's looking at who are your third parties, what interactions do they have with your employees, and where can you include those preventative measures? And contracts are a great place to start with that. And if it's not, it doesn't necessarily need to be that they have to comply with your whole policy. You can put terms. So you can put terms into the contracts that you have with third parties. You'll have them around various other things, including things like, one of the terms for the termination of the contract, for example, could be directly linked to harassment. I'm also looking at kind of briefing sessions with our third parties. A lot of this, if you think about it the same way, it's about setting the expectations in order for you to interact with our organisation and our employees. These are what we expect. These are the terms under which you have to adhere to. And it's making that clear. And you need to think about the way that you do that. It doesn't need to be in a very heavy-handed way. It can also be in a way that you use it almost as a briefing for these people, as well as I'm sure you're aware of this legislation. We are looking at it for the future. We're looking at the potential employment rights bill. So these are our standards. We're now including it in our contracts going forward. So that's the approach that I'm taking. It will be a good 18-month process probably. But starting to look at all those different areas it could cover, all those different groups of people it could touch on, and how do we start looking prior to the legislation because it's part of the cultural change as well. That's the way I see it, is if you start looking at it now, if you're trying to enact a cultural shift, or you're just trying to reinforce a great culture you have already, you don't need to wait for the legislation to do that. You can start by putting those things in place now and use it as just part of your culture.
Some really good tips there. Thank you, Sam. So we are coming to the end. We've got 4 minutes left. So my final question to you all, and I'm going to start with you, Rebecca, is what is your one top tip or final bit of advice that you would give a small business owner watching today? So over to you, Rebecca.
So I think my general point is don't panic. Chances are you are doing a lot of what you need to be doing already, but what this provides is a good opportunity to kind of pause and reflect. And as Sam and Hannah have outlined as well, is to revisit what you're doing and see how you can make it better and be more robust. The other thing as well to bear in mind is that culture change, which is the purpose of the preventative duty, takes time. So this isn't going to be an overnight fix, and this is why it's really important that you monitor and review and you revisit as and when changes externally happen or when something happens within your workplace. But generally, yes, don't panic. Take steps to make sure you're looking at this sort of holistically. And the other big thing as well is communicate with your staff, because they're the ones who are going to be able to share some really important and useful insights.
Great. And Hannah?
Yeah, I think I'd really reiterate what Rebecca says in terms of not panicking, and just remember, if you have access to the FSB Legal and Business Hub, there are resources for you, and do talk to one of my colleagues on the employment advice line, because obviously that's their job. That's what they're there for, is obviously to help small businesses comply with new legislation and just help in terms of those very practical tips, because it's all about kind of applying what you've got to what the law requires. So yeah, definitely.
Finally, Sam.
Okay, so I would say use the tools that are there that you can find from the Markel Hub or EHRC or various other places, but make it about your culture. Don't rely on it being the enforcement of a policy and the complying with legislation. Make it bigger than that and hold all of your staff accountable to it. It's all of our responsibilities to behave in the appropriate way and to be ambassadors of the right kind of behaviour, to have the right kind of culture. This is, employment is changing, and it's going to continue to change. And we shouldn't just rely on the legislation to drive it in the right direction. This is on all of us. It's on business owners to make sure they're creating the right culture.
Brilliant. You've all been really super helpful, and I've definitely learned a lot today. So with 2 minutes left, it's time is up, and all it remains for me to say is a massive thank you to everyone who's tuned in today, especially those who've submitted questions either in advance or online as we were in the live session. The event has been recorded and it will be available shortly on our on-demand page. And if you have found the event useful today, please do leave us a Trustpilot review. We really do appreciate it. But more importantly, it encourages other people to access the support and the webinars that are available to them. And then finally, a massive thank you to our brilliant panel. So thank you, Hannah, Sam and Rebecca. And we wish you all a good day. So thanks everyone and goodbye.